fiscal court meeting. Appreciate you being here. I know everybody's ready for Christmas, so we'll get on with our agenda. I'd like to ask Miss Stacy to call the roll, and then I'd like to formally recognize and welcome our newest magistrate for the 5th District, Dwayne Ellison. Glad to have you and appreciate your willingness to serve. So good to have you.
Mr. Hostetler?
Here.
Mr. Lyons?
Here.
Mr. Wallace?
Here.
Mr. Foreman?
Present.
Mr. Ellison?
Here.
Mr. Burke?
Here.
Mr. Livingston?
Here.
Mr. Marshall?
Here.
Judge Covington?
Present. With that said, let's start a meeting with the Pledge of Allegiance. Mr. Ellison, would you like to lead us? Putting you on the spot.
I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. In your packet from the 12/13/19 meeting were the minutes. Are there any questions or discussion in regards to those minutes as they were presented?
Motion.
Got a motion from Mr. Corman and a second from Mr. Livingston. Is there any other questions or discussion? All those in favor? Any opposed? Motion passes. Minutes accepted. Number 5, transfers. Any questions in regards to those transfers as presented? Motion from Mr. Hostetler, second from anyone? Second from Mr. Corman. Any other questions or discussion? All those in favor? Any opposed? Motion passes. Number 6, bills and hand checks. As presented in your packet, any questions or discussion in regards to those as they were presented?
Motion for approval.
Motion from Mr. Wallace. Is there a second? A second from Mr. Lyons. Any other questions? All those in favor? Any opposed? Motion passes. That leads us to number 7, and I'd like the record to reflect that Sheriff Hampton had property taxes presented in the amount of $2,200,612.84. And appreciate sheriffs and their department's efforts on collecting those. I know that is a huge effort on your staff's part and takes a lot of effort, so thank you very much, Sheriff. Next, number 8, planning and zoning. And I'm going to have Rand make a few comments, and then Mr. Summers from planning and zoning as well. Rand, a couple things you mentioned that I'd like you to share with the court.
Yes, sir. I spoke to the attorney for the property owner last week, and mostly our discussion was about whether it be on the agenda today, and I confirmed that with Stacy. So I called him back. I didn't get him. I got his voicemail and said, yes, this will be on the agenda. I said, I think it's going to be a matter of routine as far as I can tell, and the court will approve it. And then it occurred to me later, I need to know whether he was going to bring an ordinance. Typically, attorneys do bring them instead of us drafting. So I called him back. Again, did not get him this time, and left him a message saying, I'm operating on that assumption that you'll be here with an ordinance. If that's not the case, let me know. And I didn't hear back from him, so I thought he'd be here this morning, but there may be some confusion. I thought he was.
Pardon?
Oh, I'm sorry. I'm
Very
sorry.
good.
I apologize. Yeah, come on up.
If you'd share your name for the record.
Good morning, everyone. My name is Jacob Walburn. I'm an attorney at McBrayer Law Firm. I apologize both for my tardiness and my appearance.
It did throw me off.
Yeah. I'm getting ready to head out of town and frankly misremembered that I needed to be here until it popped up on my calendar this morning, so my apologies. I did email you an ordinance.
Okay, I apologize. I didn't see
okay,
it. That's
to
my
the
fault.
email address that you had sent. I do think this is a matter of routine. If you have any questions about it, I'm happy to share it, but I did draft and prepare an ordinance.
Okay.
That was considered. sit here if that's helpful. Or...
I tell you what, if you could, that would be helpful, I think. That way
No,
we
we
could have
can-
the first reading.
Yes.
Skip it and go down.
Could we, that's exactly what I was gonna think.
Suggestion as well.
Could
Hopefully
you
that-
forward that to Jared? And Jared, would you mind printing it? And then we could come back to it?
And I apologize.
No, no.
Are we gonna have any discussion?
Oh, certainly.
Because I was gonna say, can we not go on ahead and have the discussion?
Mhm.
And if, I mean.
No,
at that point,
my intent is to ask Matt to
that way
share.
He's obviously going out of town.
Yeah.
We don't have to hold him up.
No, my intent was to have Matt share right now. And if Jared could get it printed out, then we could have Rand share it. Matt, would you care to address the court in regards to what information you'd like to share?
Certainly can. So the property in question is a lot that has frontage on US 25 as you go north out of Georgetown. It's on the west side of US 25. It's currently about 6.13 acres. And the applicant's looking to rezone about 1.13 acres of that to, I believe, the R1A zoning district, which is a single-family zoning district from its current zoning of A1. So the applicant's intent is to rezone a part of this so that they can in future subdivide that rezoned part into its own lot so that they could have, that they could build a second dwelling or a second home on the remaining A1 zone property. So, if the rezoning is approved and the subsequent subdivision application is approved, the applicant would have one lot that's 1.1 acres in size that would be zoned R1A that has an existing house on it. The remaining portion of the property would be zoned A1 still, would be 5 acres, and I think the applicants are looking to build a house on that A1 zone portion of the lot that they would then live in.
And it's a single story dwelling that they plan on building, is what I read in the. Is that correct?
It sounded like there were maybe some health concerns.
Correct, and that's what I read in the notes. What questions or discussions does any court member have for Matt or the attorney?
I think the material said that the existing house was gonna hook onto the sanitary sewer at Moon Lake. Currently, it's on septic system, I guess. What about the new structure? Is it gonna go to this sanitary system?
Yeah, that wasn't real clear, or it wasn't for me, but, so both property, if we approve, both homes will be on the sanitary sewer, okay. I get one other question. I met the owner a couple of years ago, or maybe it's been 3 now, I don't remember, when he was working on this before. Matt, maybe you can help me. I'm trying to look at this plat. There are 2 driveways going into it, and that's in there. One of them is right up against the backside of Rifton Meadows property. Is that still just serving this property owner? It seems like that might have run back. I really can't remember. This is.
I don't believe that it is. I mean, because typically it wouldn't have created an access easement if it was just going to serve.
Well, and I don't see it.
That access
It's just for him.
easement serves maybe an additional lot, but I'd have to look at that.
You think it might?
I think it's likely, because otherwise I can't imagine why an access easement would have been created as it's shown on the plat.
Well, that's what, I guess I didn't blow this thing up. I couldn't tell. That is my recollection, though, when I met him a couple of years ago. So, but that's gonna be, if this gets approved today, that's gonna be the driveway to the 5 acres, correct? Because there's another driveway going to the house right now. Yeah, so that'll be, if it ever got fenced off, that would be that house's driveway, and then this one. But you think that's possible? I guess it doesn't matter. If it's an easement, then I think it does go back to another piece of property there. It does? Okay. Well, I'm just trying to get all that conversation back in my head.
Now, Matt, maybe you could clarify for me, the vote was 4-1 for approval, but staff did not recommend. Could you just clarify why staff did not recommend? And then, in my mind, the original zoning was A1. And since then, the conditions have drastically changed around that area in my mind, looking at everything that's built up.
Yeah. So
Would that not be one of the qualifiers for?
it's so the way that the things that we look at that the state statute lists out.
And that's what I was referring to.
So first, we would look to see if it's in agreement with the current comprehensive plan. Staff doesn't think that it is. The future land use map shows this area as having an agricultural future land use. That doesn't necessarily mean that the property has to be used solely for farming or other agricultural purposes. There's a variety of uses that are permissible as an agricultural land use residential property, as this property currently is. We have also a variety of conditional uses that are permitted under our agricultural uses, churches, schools, recreational facilities, et cetera, et cetera. So we did, I guess, in addition to that, we didn't find that it really met any of the other goals and objectives in the comprehensive plan. I know that the applicant felt differently, and I think they have some supporting materials that were submitted to staff in your packet as well. The second thing we would look at if we find that it's not in agreement with the comprehensive plan is, whether or not the current zoning is inappropriate and the proposed zoning is appropriate. And once again, we didn't really find that to be the case. There's lots of A1 zone property, both in this area and in Scott County in general, where there's lots that are smaller than 10 acres in size, where people have a good use of that property. Nobody feels like they've lost any sort of property rights, or that not able to have a reasonable use of their land. So we did not find that was the case in this area. And then the third thing that we would then look at is whether or not there have been changes of a socioeconomic or physical nature since the adoption of the last comprehensive plan, or that were not anticipated by the most recently adopted comprehensive plan. And we found that wasn't the case in this situation either, because the most recently adopted comprehensive plan was adopted in 2016, the goals and objectives, and then 2017, the full rest of the text. And there really haven't been substantial changes in this area since then. You look at things like Riften Meadows, that was created around 2005. Moon Lake, which is across the street, was platted starting back in the 60s. And for the most part, a lot of the surrounding area hasn't changed a whole lot, basically, since Riften Meadows was platted. So that's why, we not only found that there weren't changes recently in this area, but especially since the comprehensive plan was most recently adopted.
Staff recommended, if this was approved for change, staff recommended 7 things there. My question, were those inserted into the ordinance? Okay, they were. Okay. And that's a question I had on my mind. What other questions or discussions does anyone else have in regards to the request?
All right, Matt, so here's what I understand. You did reference Riften Meadows. Riften Meadows also followed the cluster ordinance, correct?
Yes.
So if in terms of looking at this rezoning, if the ordinance or the comp plan in which guides us, this is not this would be in violation of it, correct? Because it's not following. Yes. And that's why the staff recommended that it be denied, correct?
That is correct.
So if that is our guiding, ordinance or our guiding laws, then what's to keep me from, taking my 7 acres and building a house on it, and then coming to planning and zoning and saying, hey, I want to cut this little 2 acres off of it because of this application. You all allow this to happen. Why can you not allow me to do that?
I think the only thing that would potentially prevent that is the fact that there's sewer that's available to the site. But if you're the lot you were discussing happened to be along US 25 where there was sewer access, then it doesn't seem like there would be a lot, given the reasoning proposed.
But without sewer access or with sewer access, we still let the comp plan drive and govern how we develop properties. There's sewer access out on Del Plain Road. There's a subdivision that's been developed out there, and it had to follow the same rules that we govern, A1 property. So,
Chad, I'll comment too, and I kind of know where you're going with it, and I agree with you. It concerns me that it's because in that area, let's say within a couple of miles, I mean, somebody still has access to sewer and has 8 acres, or why couldn't we agree to rezone it again? If it doesn't fall in our comprehensive plan, I don't know, concerns me a little bit.
Yeah, because the problem is if you say yes, then you have to say yes here on out. You've opened the box and we've got another issue that's going to be coming up.
One other question for Matt. Can you think of another time in the last recently where they've had applications similar to something like this, where there has that this has been approved, something like that has happened?
Nothing really springs to mind. I know this applicant brought this application before the Planning Commission 3 or 4 years ago. The Planning Commission at that time didn't recommend approval, and I don't think that it ended up coming before the fiscal court.
It did.
Oh, it did. Okay. But I think that's the only, this property in particular is the only application like this, in the sense that, you know, they're requesting an urban land use outside the urban service boundary, you know, with a property that does potentially have access to sewer.
Just and I can't remember if I read this in there. So when it is recommended by Planning Commission and sent to us, what were the reasonings? Did anybody on Planning Commission give their why to go against staff recommendation?
My understanding is they went with the findings that were submitted by the applicant that I think were part of the packet. Yeah. This one. Okay. Yeah, I think there were a set of 5 findings that the applicant had submitted that the Planning Commission looked at and agreed with.
To answer Mr. Livingston's question, I've looked through the minutes, and the way the minutes reflect that there was no comments in the minutes from the commission on why what the justification was to approve it.
Well, in the minutes, there was one question asked of, I think it was Commissioner Smith, about would he farm it? His answer was no, because it's too small.
Oh, that is correct. Yeah, you're right.
And then, I don't know what page this is. I printed this off. I see 4. It says findings for approval at the top.
Mm-hmm.
And there's 4 reasons. I'm assuming that's, says these findings, it's written in, these findings were adopted by the commission in support of its recommendation to the Scott Fiscal Court for approval of the Ramsey zone change. There's 4. I don't know if you guys saw that or not, but the applicant has demonstrated that the subject property is no longer appropriate for agricultural uses. The property is in close proximity to existing single-family dwellings and is not of a sufficient size to allow for economically viable agricultural operations. That's one reason. Did you guys see that, or you want me to read on, or?
Yeah, if you don't mind.
Sure. The applicant has demonstrated that the proposed, now, correct me if I'm wrong, Matt, these are statements from the commission.
I'm not. Sorry,
Want you to, I don't know. I didn't print the whole thing.
Is that from the applicant?
That's the applicant's,
But it's entitled Findings for Approval. And then that's written by Charlie Perkins at the bottom. So that's the reasons, right or wrong?
Yes. I mean, I guess the attorney for the Planning Commission, Charlie Perkins, did write on there that those were the findings that the commission based their decision on.
And let me say that if you all are not going to affirm the vote by the commission, you need to say where those are wrong. So be prepared to do that, because there's got to be a basis for them to go forward to circuit court if that's what happens.
That was kind of where I was leading the conversation, because, you know, you look around you look around this parcel of land, and it's changed since it's originally, in my mind, originally zoned, and it's not the easiest for its original intended use to be continued for its usage, and that's why I would support the change in my mind. Yes, sir.
You just look at the map, this parcel is surrounded by similar sized tracts. I mean, it's engulfed by them.
It's not gonna be an outlier. I mean, yeah.
Scenario, because
And
it's surrounded by those type lots.
Those,
Various sizes, lots, yeah.
yeah. Oh, absolutely. No, absolutely.
And I'm not going to relitigate anything. I just want to tell you what transpired on that night so you all can have that as a basis to consider the decision. Under KRS 102.13, which sets out exactly what you have to do to rezone a parcel of property, there are 3 bases to rezone a property. One, I would wholly agree with Matt. There has not been a substantial change in that area of the nature contemplated by the revised statutes, but that's an applicable basis. We offered 2 alternative bases for approval. One is, I think there is an argument that this is in agreement with your comprehensive plan, based on some of the principles and goals articulated in the text about access to housing and more efficient use of property, and things like that. What the commission ultimately adopted, or the findings that you're referring to, I did prepare, but the commission adopted them as their own findings. And to address the question about concern on other properties, I think it would be incumbent upon another applicant to show that they have complied with those same reasons across the board to have a compelling argument that this should be applied elsewhere. There are factual peculiarities of this case that I'm happy to share with you if you'd like me to go into them. But the Planning Commission believed, and it is a valid basis under KRS 100, that the current zoning of agricultural is no longer appropriate for that zone, for that property, and that the single-family residential is appropriate, and it's on that basis that they proceeded. And it is one of 3 methods. You're right. Generally, the comprehensive plan governs your governs your land use development as a community, but they're all alternative bases that are completely viable under Kentucky law when the comprehensive plan doesn't tell us exactly what to do, and I think this is one of those circumstances.
And along what Alvin shared, if you look at the plat, it's surrounded by, by smaller, varied sized parcels. Yes, sir.
Also, Judge, the next to the last page in that document that we just passed, has got those 4 findings. If you guys want to.
So, is there
Yeah,
is there any other question or discussion?
I would argue that with one of these 4 points that you made, that the applicant said this was no longer appropriate for agriculture uses, I think that's an opinion. That's just that individual's choice. I have less than the 7 acres that the applicant's asking that I operate agricultural purposes on. So, I mean, that's an individual choice.
I understand.
And so if we're going to let this govern us, and we're going to say, hey, that's the individual's choice, that's not what the comprehensive plan's saying. It's saying that A1 zoning is A1 zoning for a purpose. It's an individual's choice to do that or not. And you can't use that as, in my opinion, you can't use that as justification on why you should reduce you should compromise the comprehensive plan.
I think also, I agree with what you're saying, but to take it a little bit further, when it says it's not viable for agricultural operations, there's also conditional use permits. So to say A1 is inappropriate is not accurate, because there are conditional use permits that could be used for that property. So the A1 could be appropriate if there were requests for conditional use permits for other reasons for that piece of property.
And in response to that, I would say 2 things. One, sir, in response to your point, there was evidence submitted at the hearing. It wasn't just an opinion asserted. There were factual bases for what was contained in that should have been in the record that was transmitted to you about the financial viability of agricultural parcels. So while that statement may ultimately be an opinion, it was supported by facts in the record that were not rebutted at that hearing. In response to your issue, and I can certainly understand where you're coming from on that. However, when we look at the purpose of zoning, we need to look to the intent of the agricultural zone. The intent of the agricultural zone is for farming operations.
Oh, you're right.
Yes.
But how many things have been done before outside of the intent passed by the Planning Commission against the recommendation of the staff?
Well,
I mean, that's what you have to go back and look at, and that's what we have to make the decision on.
We were frankly very disappointed in staff's opinion, because when the application had been brought prior, the 3 years ago, it was recommended for approval by the staff, and there had been no factual circumstances that had changed, so we were a little taken aback by that. But what it ultimately boils down to is, as far as the law is concerned, as far as KRS Chapter 100 is concerned, is has there been demonstration, is there substantial evidence in the record, and I would submit to you that there is, that the current zoning classification is inappropriate and that the proposed zoning category is appropriate. It's those findings that the Planning Commission seized on. Now, I'm happy to get into some of the factual circumstances if you would like. It's a just under 7-acre parcel. There are a number of issues with agricultural uses on that property. Aside from that, there's a retention pond on that property. There's places that you can't do agricultural operations. We can get into some of the nitty-gritty if you'd like. That's typically not what happens at this stage, and so I won't proceed there.
I'd like to ask Matt if he could confirm the statement that 3 years ago when this was brought up, that staff did recommend a change.
Yes, staff did recommend approval. The application came 3 years ago. I would like to note, however, that was under a different comprehensive plan, and I was not the planner that reviewed the application at that time, so I don't know I don't remember off the top of my head what findings may have been made.
But I couldn't think of any changes in the comprehensive plan before 16 to now in that area. Would you all agree with that statement?
Well, the comprehensive plan, in my understanding, is it's a guiding document. There's no way for that plan to address every issue. That's why we're here this morning.
And I would agree with you, Mr. Ostetler. I would say that just based on, is R1A appropriate now for the reality of that parcel where it sits? And R1A, in my mind, is appropriate for where that parcel sits because of the surrounding, what's surrounding it as we speak. Now,
Is it an urban service boundary?
I don't believe so.
It's not. I have one more question for Rand. Rand, are we setting a precedent at this point by approving this, moving forward, that the next applicant that comes to us, that they can use this as, hey, this body approved this, can they use that for justification in something similar to some type of example like I used earlier, or something I'm not even thinking about?
Oh, yeah, I'm sure somebody could. Now, it sounds like to me there are a lot of things that are unique about this property that maybe make it not suitable for farming. Here's my biggest concern. I misread the room, obviously, because I thought this was kind of a, they recommended 4-1. I just wrongfully assumed you all would be fine with that. If you're not, that's fine. But you need to make findings of fact that support whatever you do. You can adopt those if you're going to vote to approve it. But if not, you've got to say where those are wrong and make your own. And I don't know, I think that's hard to do when you've had, the whole commission hear the thing and hear all the facts.
But the commission's no more professional planners than we are. The
No, but-
staff are the professionals.
That's true, but
So
they
we adopt, if we decide not to do it, you adopt the recommendations by staff. That's all we'd have to adopt, correct?
No.
We wouldn't have to give our own reasons, because I'm not a planner. That's not what I do. I'm a magistrate.
I think the thing about it is, though, the commission had the benefit of hearing all this and voted 4-1 to approve it. Again, I was wrong. I thought this was kind of clean cut, and it's not. But I think, what they're going to do if you don't approve it is go to circuit court. So we've got to lay a foundation for whatever you all vote to do, is what I'm saying.
But that's not all inclusive. You could just find that one of these recommendations is wrong, and it could be a reason for denial. You don't have to prove that all 4 of them recommendations by staff.
You just have to make your findings of why you're going to vote against the commission. It could be one reason, it could be many. Yeah.
I would go back to and we can certainly ask for it if we want to, but 3 years ago, in my mind, there's nothing changed from 3 years ago to now, with the staff approving it 3 years ago, and now denying it.
And I would just say that the staff's basis of approval for the prior application is exactly the same basis of approval that the Planning Commission has done here. They did not find it in agreement with the comp plan last time either, but did agree with the applicant's position that the prior zone, or the existing zoning was inappropriate and the proposed was appropriate. And if you are inclined to disapprove this application, I would strongly request and certainly suggest, though you should rely on the advice of your own counsel, that you hear this matter in whole before making those decisions, because otherwise we may just have to do it again.
But the problem is, this is dated 2 months ago, 2.5 months ago. We just received it last week. So, you know,
And-
we've run in so many times that we roll to the end of the year at the very last meeting that something comes up that's very important. And I don't like that, because it doesn't, it just feels forced.
And
And so when it feels forced, I'm going to defend even more vigorously and err on the side of caution of not doing it, as opposed to, had we had more time to do this.
And let me clarify on that. I do believe we just received this last week. And the reason it is on your agenda today is because there is a 90-day requirement for this body to hear this. And if we would waited until the January 10th meeting, it would be day 91.
Is that something you
and-
feel like, I'm sorry,
No,
that
go
you all
ahead.
can waive and would be willing to waive the 90 days?
I mean, certainly it's not our preference, but if the alternative is taking a disapproval, I think this application, and I said it in the Planning Commission hearing, is one of the most compelling I've seen since I've been doing this. This is a very deserving application, and if you're inclined to disapprove it, and I certainly understand the policy arguments that you gentlemen are making, it's not that those fall on deaf ears. There are individual facts and circumstances related to this case that are reflected in the findings that were adopted and reflected in the record that was adopted by the Planning Commission, that I think it doesn't need another hearing, that I think your basis is sound, and I think it would serve to combat against future people who might be trying to take advantage of that. That said, you know, we're willing to have a discussion if it's the difference between taking a disapproval today or not. I think you all should hear the entirety of the case if you're going to make a decision that's contrary to the record that's in front of you. There wasn't an opponent that appeared at the hearing. They had universal support from their neighbors.
There's several signatures
Yeah, there was a
of
petition
support.
that was included in the record. But I'm certainly willing to have that conversation if the alternative is that these folks are turned away again, because on personal circumstances, they have a need for resolution on this. This was driven by a medical situation, and if they're not going to be able to proceed with their plans, and I'm happy to share as much or as little with that as you'd like to hear, but I think that was also a significant component of the Planning Commission's decision.
Rand, will you lay out our legal options of what our choices are? We've got multiple choices here with this application.
Yeah, well, yeah, you can affirm it, or you can deny it, or you can have your own hearing, I think, which is what you're suggesting, and hear the whole thing all over again.
Or the fourth option is we don't have to take any action.
If you don't, yeah, it'll pass.
Yeah, so, I mean,
that
if
was a vote.
this body takes no action, then it falls back to Planning and Zoning Commission, and it would pass. And that's not what I'm recommending, but I did want to lay out all the legal options that the court could consider.
Judge, sounds like a motion's in order, and I'll make a motion that, on recommendation from the planning staff, that we do this ordinance change. I don't know how to,
So you need to read it first.
From the
Motion.
commission.
yeah.
Yeah.
Planning Commission.
From the Planning Commission.
I'm sorry.
Approve the zone
Yeah.
change.
Thank you.
So your motion would be to approve the change, the ordinance change, which is essentially changing it to R1A.
And only one portion.
That one portion.
That one portion.
So does that go along with what you'd like to?
It's what Rand wants to read it, yes.
So Rand has to read the ordinance,
Well,
and then we can call it.
Then we need a second.
Yeah,
Yeah.
that was, okay.
All right.
All right, well, let me read this then. You know what this would be, Stace?
Yes, 1913.
Thank you, sir.
Ordinance 1913, ordinance changes the zone from an agriculture A1 zone to a single-family residential R1A zone for 6.137 acres for property located at 2394 Cincinnati Pike. The Bonnie Smith, formerly known as Bonnie Ramsey property. Whereas at a public hearing held on October 10th, 2019, petition for a zoning map amendment for property located at 2394 Cincinnati Pike from an agricultural A1 zone to a single-family residential R1A zone for 6.137 acres was presented to the Georgetown Scott County Planning Commission. The commission recommending approval of zone change by a vote of 5 to 1. Whereas the Scott County Fiscal Court agrees with the recommendation of the Planning Commission. Whereas the recommendation of the Planning Commission is reflected in their minutes is attached here too and incorporated by reference herein. Now therefore be ordained by the Scott County Fiscal Court, Section 1, that the zoning ordinance of Scott County, Kentucky be amended to show a change in zone for property located at 2394 Cincinnati Pike from agriculture A1 zone to single-family residential R1A zone for 6.137 acres. Section 2, that the conditions of approval for the zone change imposed by the Planning Commission are hereby adopted by the Fiscal Court as attached here to and incorporated herein by reference. Section 3, the findings of the Planning Commission which are attached here to and incorporated herein by reference are hereby ratified and adopted by the Fiscal Court. Section 4, that the Georgetown Scott County Planning Commission is directed to show the amendment on the official zone map atlas to make reference to the number of this ordinance. Section 5, that this ordinance shall become effective on the date of its passage.
We have a motion, we have a second, we've read the ordinance.
Judge, this is just first reading, correct?
Correct. We need to do a roll call?
No.
No. With that said, all those in favor? Any opposed? Motion passes. Yes, sir.
This is first reading, so we just have to have first reading before 90 days. And we can have second reading after 90 days.
That's my
Good.
understanding.
That's a great question,
not mine.
Squire.
Okay.
Yeah.
Is that incorrect?
So you're saying we now have to have a special meeting before,
If you're gonna
January 10th.
turn it down, you do, yes.
well, but I mean, we did a first reading. We either have to accept them, we have to have a second reading, right? I mean, you
Have to have a
can't
second reading.
First reading and not have a second. So we have to have a special called meeting now for a second reading.
I'm not your attorney, but I don't think you do, because
I'm not under the impression you either. We've had the first reading within the time. That's my understanding. It's-
Could Rand clarify,
I'll
I
double
just wanna
check
make
that.
sure we don't wait until January 10th and go, oh,
Yeah.
guess what, you've gotta start all
No,
over again.
it's a
because-
great question. I'll ask Rand to clarify that and share with the court.
Yeah, I'll get with you and we'll.
okay.
We're gonna be here on the 3rd, so we can have.
Yeah.
Yeah, we have a
Workshop.
scheduled for the 3rd, but if we had to have a special called meeting, we could.
Okay. Well, again, I apologize for any confusion and certainly for
No,
my.
safe travels, Merry Christmas.
Appreciate it. Merry Christmas to you
Yes.
all. Happy holidays.
We'll move to the next item, animal control, new hire. Mr. Mudrack, how are you this morning? Matt, thank you. Merry Christmas. Jeff, go ahead.
Thank you. Yes, I'm very pleased to recommend to you the appointment of Kevin Stanfield as our new animal control officer. He's replacing Katie Moreland. And as you can see from the resume I shared with you, he has 4 years' experience working in a similar capacity with Lexington. And I think he'd be a great addition to our staff here. The pay for him would be $13.89 an hour, and we're anticipating or recommending a start date of January the 6th. So.
Any questions or discussions for that recommendation from Mr. Mudrack?
Just one quick clarification, and then you just said it, and I've read through a lot of this. You say he's got 4 years' experience?
4 years, that's correct.
That's what I thought, and that's what I remembered.
Any other questions or discussion? Would there be a motion to accept that? Motion from Mr. Lyons and a second from Mr. Hosteller, is that correct? Any other questions? All those in favor? Any opposed? Motion passes. Thanks, Mr. Mudrack.
I'll be stepping away. We have 322 people who applied for the deputy clerk position, and we're doing interviews right now, so.
Okay. And
322?
and you're going now to help do that? You're going right now to do those interviews? So that's awesome. Appreciate it. Next, number 10, North Hamilton lease, Commonwealth Attorney office space. Are there any questions in regards to that document?
The question I had, it's the same amount that we were paying the last year.
Right.
Yeah, okay.
Would there be a motion to accept?
Motion for approval.
Motion from Mr. Wallace. I see a second from Mr. Ellison. I saw a second from Mr. Ellison.
I'm on the books.
All right. Any other questions? All those in favor? Any opposed? Motion passes unanimously. Next, number 11, disposition of firearms, KRS 65.041. And Sheriff Hampton, would you please share with the court?
Yes, as Captain Porter brought up at the last meeting, we'd like to have the ability to surplus firearms to retired deputies at a fair market value. I shared the KRS with Rand, which is 65041. What I'm wanting to surplus today is a Glock Generation 4 Model 17 with case and 2 magazines, serial number ZLE789, and I would present a check to Stacy for $200 that would go towards the general fund.
Do we need a motion?
Yeah, I have one question for Tony. As far as in terms of how do you assess the value, you do it with trade-in value or?
Trade-in.
Okay, so whatever the trade-in value is what you charge back to the deputy?
Correct.
And these, how many weapons are we talking about, Tony?
This is just one.
Just one. And so that's a purchase price of whatever retiring officer is going to pay for it, the 200 something?
Right.
Okay.
In my understanding, we do not need a vote.
Yeah, the way I read this, and I don't think there's any harm in it, but yeah, the way I read this statute, it's kind of a specialized statute that allows you, if fair market value is paid by the retiring officer, to sell it to them.
But if the court would like to entertain a motion, I certainly support that.
It's however you all want to do it.
We marked it as no action. I don't know if that
But
matters.
will we have to surplus do we have to surplus the item every time that this transaction takes place?
Not the way I read this thing. I wish I could read it now, but it's so tiny and I can't make it.
I brought it.
Okay.
I thought you were wrong at first, but now I've read it again. I think you're correct. It doesn't mention it?
Yeah, it didn't say anything about surplus, and it just says sale to the employee to whom the firearm was issued if all the following are satisfied. Now, I do think the money has to go for particular purposes, but that's kind of wide open. Firearms, ammunition, range facilities, or a combination thereof.
Mr. Burke?
In my working relationship with many of the counties out in eastern Kentucky, this is done fairly regularly. And I would make the motion that we go ahead and approve this.
There's a motion on the floor. A second from Mr. Hostetler. What's,
Have to I mean,
No.
it's under his purview. I don't want to get into.
The only reason I ask is because I marked it as a non-action.
Yeah, he's asked for a motion. Let's just give it to him.
I probably would be more comfortable just in the future, just bringing it before the court, being very transparent about what we're doing. Absolutely.
But you all will keep a log, right, of what you're.
Absolutely.
Yeah,
So
if
just
we make a
note it in the
motion now,
minutes?
then it puts us in a precedence of.
We can go ahead and vote on it. Well, I guess.
well, the situation is we're in a special called meeting and she marked it as no action.
So, yeah, I think we just put it, if somebody has an objection, they can voice it, but I think otherwise we just put it in the minutes that Tony informed the court that's what he was doing.
Let the record reflect that request and the statute, so.
Yeah, and we can just add, to keep it as a transparent kind of thing, I'd already kind of figured I would basically type up same thing, listing the weapon and the serial number and who it was.
Have it brought to the court and.
Kind of thing, and have that turned in and she can.
So the record can reflect it.
It's best to keep this transparent, otherwise you end up with a rack of shotguns and a pallet of 9mm in your garage.
Right. And Stacy, check Scott Fiscal Court. Okay.
Yeah, thank you, Sheriff.
Thank you all.
And Gerald, and Merry Christmas.
I withdraw my second.
You withdraw your second? All right.
Please excuse us, we have an exit interview with
All right.
our auditor.
Thank you. Next, Tony, real quick. Nothing. We'll get it straight, because you signed that for me already.
Okay.
No problem. Thank you.
All right.
Good luck today. Now, number 12, Charles Sutton Field Lighting Purchase Agreement. And
And before we get into that, Judge, can I say, in talking to Dwayne, it sounds like he's had some involvement with the school system on this, maybe some, recommendations. So probably he should recuse himself and step outside.
Me.
You need to, too, right?
Yeah, that's this company that is a sub of mine.
Okay, so maybe both of them.
certainly would defer to your judgment and wisdom there.
Well, I don't know if I have that, but probably the safest course, yeah.
But I shared with the court that the school board desires to partner, and the way they proposed to partner on the lighting project. The lighting project needs to be done because the lights currently do not meet KHSAA standard, and the Scott County High School team plays on that field. They have proposed to partner with us on permanent lighting, and their board attorney has recommended that they partner with us through an addendum to the SRO agreement that for the next 3 years, $50,000 a year would be budgeted in, and we would invoice them for SRO services additional to the current SRO agreement. Rand's reviewed that, Tony's agreed to it, and Tony signed that. With that said, I shared with you a proposal from Musco Lighting on Friday that would install new lighting at Sutton Field. And what questions or discussion does anyone have in regards to that information that I shared with you from Musco Lighting?
Judge, the only thing I'll share is that I reached out to Musco earlier this week to ask what's going to happen to the existing poles. And I think there is alternative uses that the county parks might be able to utilize the existing poles at another field. So they have verified that. So there is a alternative use to what sits there now for something maybe in the future.
It would be a good use of resources.
Yeah.
I appreciate you doing that. The proposal is for new lighting under a Sourcewell agreement, and that total would be for $307,788. Are there any other questions or discussion in regards to Mr. Burt?
Are we still looking at Verizon putting up a cell tower and using that to put lights on?
Bill, I have reached out to the Pike Legal Group repeatedly, and the last request that we had was for them to provide us drawings of what exactly they wanted to install there. I have not received any, so at this point,
March on.
yes.
Okay, my second question, and I've said this earlier, you know, why don't we just call this what it is and say, look, we're doing this to replace lighting. We don't have to have an impropriety, we just have to have the perception of impropriety when you know, rather than pay extra money in the lease to get lights, we're now gonna play this shell game and move it over here for you know, SRO. I'm uncomfortable with that. I'm not entirely uncomfortable with the purchase of lights. I'm uncomfortable with the shell game that we're playing.
Well, let me speak to that, please. And I worked with staff from the school board, and we presented this originally, and we approved it in a usage agreement. When that usage agreement was reviewed by the school board the school board attorney, his advice was that they could not approve that. And I feel like I've been 100% transparent with the court and anybody else.
I'm not doubting your transparency.
Yeah, and I don't understand. Rand and I both asked the question why that could not be approved through the usage agreement. I'll be honest with you, I've never gotten that answer.
Yeah.
So that's just before I get in it, and after that, it was presented to me. Well, you know, we would like to still partner on permanent lighting, but in lieu of the usage agreement in the Parks and Rec usage contract that's been in place for many years, they proposed $50,000 a year for 3 years be added in an addendum to the Sheriff's Office SRO agreement. Their board attorney said they could do that. I've talked with Rand, and Rand, do you have any comments on that?
No, I don't, I'm like you, I've not been given a reason why we can't just do a $50,000 a year provision under the usage agreement. But for whatever reason, the school attorney sees it that we can't. So this is the way to do it. I don't disagree with Bill that it's not the best way to do it, but if you all find that it's an appropriate way, maybe not the best, but one way to do it.
I'd rather them give $50,000 to Parks and Rec and we just reduce Park and Rec budget by 50. I could live with that rather than playing this shell game, you know, and trying to.
I don't think he would say that's permissible just because they are a party to that agreement now. And again, I don't know why, Bill. I can't give you that answer.
I'd like to make a comment too, just, when we started this agreement, I never thought it was the fiscal court's responsibility to pay $300,000 for lights that needed to meet Kentucky High School Athletic Association standards.
Yeah, well, I've been down that road.
And I'm not here to rehash that, but we did agree in previous meetings to be a good partner with the Board of Education and pay half. And I think that's good, and we're gonna hopefully do that, and then, I'm okay with this current situation with the way that we're doing it.
Mr. Lyons, thank you, Kelly.
This is not going to be completed in time for the upcoming season, so the temporary lights are still going to go in. Musco going to coordinate so that.
Musco, I've spoken with Kurt Mickey of Musco, and he thinks that the temporary lighting would be installed and the possibility of the permanent lighting, the installation being complete before the end of the season exists, but it's all due upon a variety of factors on getting it shipped and then weather and such. If in a perfect world, the permanent lighting would be installed, the temporary lighting removed before the end of the season.
I would certainly like to see this done a lot cleaner, but this is our ball field, it's our responsibility. So I move we proceed with this agreement.
Got a motion, is there a second? A second for Mr. Corman?
Yeah, Corman.
Any other questions or discussion? All those in favor? Any opposed?
I'm going to abstain, Judge.
Abstain, all right.
Can somebody
So
get?
I have 2 recuse and 1 abstain. Is that how I'm gonna word that?
Yes, yes, ma'am.
Motion passes still, correct?
Judge, you'll, at this point, I would assume you'll coordinate with Musco and.
I'll do it today.
Yeah.
Yes. All right. Any other questions in regards to that? We'll move on then.
Is anybody gonna get Rick?
I think, yeah, I think.
Yes. Fire Department new hire. We'll have to wait until they get back in. Chief Fuller.
Might take Chief Fuller that long to get back over there.
Judge Covington, members of the court, Ms. Stacy. Want to conditionally recommend the appointment of a new firefighter. His name's Nicholas Carson. It's contingent on him passing his physical, which we've done in the past. Actually, he took it this morning, or should be finished with it by now, but we probably won't have those results for a week or so. But he would start date would be January the 13th, and it would be at $10.50 an hour. For a firefighter we had resigned a couple weeks ago.
He comes to us with experience as well, doesn't he?
Yes.
Very good.
I think he had 6 or 7 years on Paris.
Yeah. What questions or discussion do you have for Chief Fuller? Motion to approve from Mr. Lyons. Is there a second?
Judge,
A second from Mr. Burke.
I do.
Question?
Just a comment, because he had like 6 years, did you say?
He's got 6 or 7 years experience, yeah.
Yeah, just
6 years' experience, the starting salary is a little bit low.
that was my,
Well,
just gonna make a comment there.
and then
Especially
the
compared
whole
to.
sticking to our guns.
Right.
Sticking to our guns of what we've pledged to do is to allow Jeff over the next, month and a half to bring to the court how we will reflect experience in similar positions.
Well,
To your point, that's why I went ahead and seconded it, because, Mr. Mudrack's not here, and with the hopes that when this guy, if he does agree to come on for this rate of pay, we'll be able to make some kind of adjustment for experience in the next month or two.
That's the plan.
Well,
So my second stands.
Okay.
well, to finish my comment, I was looking at 4 years' experience for the animal control new hire, but that's substantially higher starting pay, and was kind of an issue with me as well. And looking at this fellow's got 4 to 6 years, I think, 6 years' experience, so a little disparity there.
But we can certainly ask Jeff to look into it. But that's, just trying to be consistent until we look at all of them and how we want to. And there's been questions brought to me, concerns about, if you have a law enforcement officer, a firefighter that's been apples to apples in another position, it comes to us, how do we accurately reflect their experience?
Right.
And I think it's important that we try to take that experience into consideration when we compensate them and where we put them in our compensation structure.
Well, I'd ask Mr. Mudrack to take a look at the starting pay for the animal control. It's not about that individual. Please don't misunderstand me. It's not about this firefighter applicant either. The individual it's not about. It's just about that disparity, and they both have experience starting out.
Yeah.
I think one's just obviously, in my opinion, it's a skilled trade, and you got two different people in different ranges and what they're doing. It's not two firemen being compared, right?
No, it's not.
Right, so I defer to HR just for
That's
them
why
to
I'm,
use it.
that's why I'm
Based on that
bringing
median,
up.
everything's been based on that median that's been,
And I think that's the fairest way we can do it.
so we'll look at it. No, I think it's important to always look at it.
It's the work schedule is totally different from the
Yeah,
firefighter to
animal,
the
yeah.
animal control.
Well, and just what you
That's
pay
entirely
individuals in different jobs.
totally different work schedule.
Any other questions? So we've got a motion and a second. All those in favor? Any opposed? Motion passes.
One other thing quick, because Rick asked me before, but our firefighter is in the hospital recovering from the open heart surgery.
It's because of special called meeting.
Oh, okay.
I can send an email out. I've been updating them just so you know.
I didn't think about it, but doing better.
Yeah. Hey, that's good news. It's not really in the record. All right. With that said, I'm going to ask Mr. Wallace to speak to Ordinance 1912, first reading, Weisenberger Mill Road.
Yeah, if you don't know, at 8 o'clock this morning, Weisenberger Mill Bridge opened up since. We should clap. So we're very excited about that. Back in October, Woodford County Fiscal Court passed a no-through truck ordinance that they are trying to prevent large semi-trucks from coming down Weisenberger's Mill
From their
Road
side.
from the Woodford County side. And they reached out to JR, and JR had contacted me, and we thought it was appropriate we do it from our side, from the Leestown Road side. I have talked with Mac Weisenberger. He is in support of this ordinance. It doesn't affect his business at all. So
They have a
that's kinda-
turnaround there at their business. And
Yeah, they do. So they're just, the goal is to try to keep semis from coming down Weisenberger's Mill Road and going across the bridge.
But the bridge will handle it if there's a local delivery because
Yeah.
you can buy something offline and it can come in a tractor and trailer to your house, which would serve some of those folks.
Mac relayed to me that they direct all their traffic to come down Leestown Road
Gotcha.
to come into the mill that way.
But I think what you were referring to is residential.
Homeowners, yeah.
Yeah, it can accommodate ambulances, fire trucks, school buses. It can take the weight. It's not recommended though.
No, I get it, and that's what this is trying to take care of.
That's correct.
Will there be signs put up, or how's that?
They already, my understanding, Woodford County already has their signs up at Old Frankford Road, and right as you turn off of Weisenberger's Mill, well, it's South Weisenberger's Mill onto Weisenberger's, where the bridge is, on the Woodford County side. We're gonna put ours on the Leestown Road in Weisenberger's Mill Road.
It's in the ordinance.
They have a guard tower with spotlights and machine.
I did have one question.
Yes, sir.
There are quite a few farmers that operate on both sides of that bridge. If they hauling hay across there, is this gonna affect them? If they got a truck and a couple wagons loads of hay behind them? I mean, technically, that's commercial
I
activity.
think we're talking about commercial vehicles.
Well, I mean,
Tractor trailer trucks.
but by the strict definition, vehicle.
The ordinance reads
considers it-
commercial motor vehicle.
Yeah, I don't know if that would fall under.
Could we put in there, could we amend it and say not to include
Farm vehicles have a
farm
license plate?
activity?
Yeah, but vehicle enforcement still considers that a commercial vehicle.
But if we put in the ordinance,
Most of them don't, they'll overlook it, but
But if we put in the ordinance to say not to
Exclude
include agricultural activity,
I would feel better with that, just to make sure.
I like that.
can you do that on the fly?
Oh, yeah, we'll just add it in
Do
here.
what he said.
Well, and that, when we were discussing about the bridge construction, that was brought up, and, I mean, obviously, it can hold that kind of weight.
Yeah.
But that's not what the intent of the ordinance should be.
But if we have it on paper,
Yeah.
you'd feel better, Alvin.
Yes.
I agree.
Because like I say, vehicle enforcement considers ag vehicles commercial. So, they generally overlook it, but
Vehicles used for agricultural purposes, will that,
Or can you
Yes.
just
Read
read
it with that in it.
yeah, I'll just read this.
Rand's gonna read the proposed ordinance, and then we'll see if we have a motion to accept as read.
This is 90-12, an ordinance banning commercial motor vehicle traffic on the Weisenberger Mill Bridge, whereas a new bridge has been constructed on Weisenberger Mill Road between Scott County and Woodford County, and whereas in the past, commercial motor vehicles have used the bridge on Weisenberger Mill Road and have caused damage to the bridge, and whereas the Woodford County Fiscal Court has banned commercial motor vehicles from using the bridge to preserve the same, and whereas the Scott County Fiscal Court desires to preserve the bridge as well, now therefore it is hereby ordained by the Scott County Fiscal Court as follows. Section 1, all commercial motor vehicles are hereby banned from use of the Weisenberger Mill Road Bridge. Section 2, commercial motor vehicle is used in this ordinance, and this is right out of the state statutes, is why I use this language, shall mean a motor vehicle or combination motor vehicle used in commerce that is A, designed to carry property and have a gross vehicle weight rating as determined by federal regulation which has been adopted into Cabinet Administrative Regulations pursuant to KRS Chapter 13A. B, designed to transport 16 or more passengers, including the driver. C, transporting hazardous materials and is required to be placarded in accordance with Title 49 Code of Federal Regulations, Part 172. Or D, any other vehicle that is requiring a Cabinet Administrative Regulation pursuant to KRS Chapter 13A to be operated by a licensed commercial driver. However, the following shall not be included in the definition of a commercial motor vehicle: school buses, fire trucks, ambulances, and vehicles used for agricultural purposes. Section 3, Scott County Road Department shall post a sign stating, quote, no commercial vehicles, unquote, or similar language in an appropriate location in Scott County prior to approaching the bridge. Section 4, this order shall become effective upon its passage and publication as required by law.
Any other questions or discussion? All those in favor?
And I'll make the change in.
I don't have.
Oh, we didn't have a motion, did we?
Yeah,
I'm trying to move
I'll
us
make the
along.
motion, Judge.
Chad makes a motion. Is there a second? Second for Mr. Lyons. Any other questions or discussion? All those in favor? All right, any opposed? None opposed.
Hey, we got to
I'll
vote
change
twice.
it.
I'd like to ask Mike Hennigan to address the court in regards to a EMA grant project that's located on Leesburg Road.
That's correct, Judge, magistrates. We have a property in Scott County that fits special kind of criteria. They fit under the flood mitigation assistance grant. Relatively frequently, FEMA offers mitigation grants, which would be a 75% federal match, 12% for the state, 13% local. In this particular case, because the property is a severe repetitive loss, they qualify for a different program, the flood mitigation plan, which would give us 100% reimbursement for the grant. What I'm seeking today is a letter of approval from the court to move forward with this project, and statement that if approved by FEMA, the county would pay the initial cost with 100% reimbursement from the federal government. After doing the cost-benefit analysis, qualify for about $275,000. My estimate is that it would be a $250,000 buyout for these people and $25,000 roughly to destroy the structures and remove the debris.
And then at the conclusion of that, the Scott County Fiscal Court would be deemed
in possession, yeah,
in possession of that parcel of land.
Yes.
And part of the agreement lays out that there no structure can be built back on that piece of property.
That's correct. It has to remain green space. It could be a park or Yeah, all kinds of different uses for the land, as long as nobody lives.
Could it be sold for agricultural purposes only?
Yes, I believe that that would be a case.
So if some landowner nearby wanted to buy it just to farm,
Yeah,
and it could be.
as long as the land remained 100% able to absorb the water. No structures, no parking lots, nothing that would change. We've got a long history of how this property came to the position that it's in, and I don't think that this is the appropriate place to get into that.
I agree.
But
the question before us is, do we want to give a letter of approval for the grant?
So this letter, if we do it, FEMA will take that, and then if they say yes, they approve it, they're gonna send the money, then the court would take action on the property? How's that final answer?
the way it would work is if the grant is approved, the federal government would send us a letter saying, we have earmarked $275,000. Once you show us proof of work and the final, that the land is, cleared and reseeded essentially, then they would release that check and the fiscal court would receive the check for $275,000.
And you shared with me that the landowners have tried to absolute auction the home.
That's correct.
They've tried to sell it commercially,
Right.
and those have not been successful because of the.
Yeah, they purchased this property in late 2005. Neighbors, former magistrates, other people came to them shortly after the purchase and explained how badly this property flooded. Within 6 months of closing on the property, they put it back up for sale. It's been for sale numerous times. Like the judge said, they tried to absolute auction. There was not a single bid. Nobody showed up.
Yes, sir.
What about an environmental assessment in case you go in and start taking it down and there's, how do we know there are no issues on the property?
You do a phase one study.
Right. But my question is where's that, is that a consideration? Is that required? Is that paid for part of the grant? How does that, what if you went in and found an issue? Would we be on the hook for something like that?
That's not part of the grant.
Okay.
Because it is residential property, never been industrial, I didn't go into that piece.
Okay.
They put meth labs in individual houses.
Okay.
Well, I'm quite clear, and we've cleaned up numerous meth labs, and
But so this has always been either
100% agriculture.
Okay.
Yes.
Where is this property?
257 Leesburg Pike. It's right
Lyons.
next to the box culvert that they put in there, and now every time it rains, all of the stormwater from the neighborhood comes right onto this property.
I was reading some of the material, I forget, I don't see it right now, but that there's argument this should never have been approved for construction, which is obvious. But does the county have any liability because of that? And does this action, would a release be required so that we do not have further?
I didn't hear that question, Alan, I'm sorry.
I said, there was a statement in some of the materials that this should never been approved for construction on this site. So does the county have any liability in that regard? And does this action require them to sign a release that we do not have any further liability in that?
Well, I mean, I think always the potential is there for them to sue us for having approved. I don't know if that'd be planning and zoning, the building inspector, who that might be.
I believe that this has pretty much been all litigated because they did take action against the county for widening the road and increasing the box culvert. That was back in 2008 or 2009.
That litigation has been resolved? Is
Yes.
that okay?
Said that the county went through all legal processes to improve that road, and I can give you a copy of that case. I have that in my file.
Was the county found responsible in any way?
No.
Okay.
But the statement that Magistrate Lyons is, that was something that I put in the email to the judge. When this property was built in 1988, there was some question at that time whether or not that was a prudent move, because everybody knew that that was the lowest point. You know, all water was always going to go in this place, and that person that built the two-story split-level house with most of the living structure under the water line wasn't the most prudent move.
So it wasn't a floodplain when they built it, you think? The flood map showed it, or you know?
I don't know. I can go back and check.
That doesn't make a difference to me. I don't think FEMA will allow you to build a house now that's in a floodplain.
That's correct. I'm sure it was in the floodplain. I don't think that there was building codes regarding the floodplain back then.
Right.
Any other questions? Is there a motion from Mr. Hostetler to approve the letter of support? Is there a second? Second from Mr. Wallace. Any other questions or discussion? All those in favor? Any opposed? Motion passes. Thank you.
Thank you, Barry.
Next, we'll go to Clerk Surplus. And do you have a list of that was included in the?
Hopefully everyone has it. It's a lot of just miscellaneous items.
And we've got 4 computer keyboards, 1 Sharp adding machine, 1 Swingline automatic stapler, 1 steel case cash drawer cover, and metal lockbox, but there's no key, and then a black box Rolodex office runner headset and base, and then Sennheiser phone assistant lift.
And 2 phone cords.
2 phone cords.
And a part of phone cord.
Is there a
Motion to approve.
motion to approve and a second from Mr. Hostetler? Any other questions? All those approved, all those in favor? Any opposed? Motion passes. Number 17, airport board joint appointment, shared in your packet. I believe it was Mr. Steve Woodrum, and it's actually a reappointment to this, and he has served prior. Mayor Prather has recommended him as well to City Council, since this is a joint board appointment. Is there any questions or discussions?
Motion.
Motion from Mr. Corman. Is there a second? Second from Mr. Livingston. Any other questions? All those in favor? Any opposed? Motion passes unanimously. Parks and Recreation Board appointment, I'm excited to recommend myself to you all, Dr. John Travis. Dr. John Travis is a 40-year educator, a former Parks and Rec Board member as well, a local pastor, and I would wholeheartedly support his. Yes.
He'll make the motion, I'll second.
All right, very good. Any other questions? All those in favor? Mr. Ellison made the motion, and a second from Mr. Burke. So, any other questions? All those in favor? Any opposed? Motion passes unanimously. Ethics Board appointment. I'd like to call on Magistrate Wallace. Magistrate Wallace actually recommended Jerry Ann. I know Jerry Ann Langford as well, a lifelong educator. What would you like to comment, Mr. Wallace?
Just that she's, I think she'd be an excellent candidate for the board. Works at Georgetown College, and also in Scott County Schools.
So, any other questions?
Is that a motion, Chad?
Motion.
Motion.
Second.
Second from Mr. Corman. Any other questions? All those in favor? Any opposed?
Excuse me.
Motion passes unanimously. I have one other Ethics Board appointment that needs to be made. I have actually reached out to a couple of potential appointees and don't have a firm name to recommend at this time. So if anyone has any other potential board appointments in regards to that, please let me know. Number 20, pending declaratory judgment update. And I'd call on Rand and Master Hostetler to share. Rick and I made a phone call earlier this week to John Maybrier at the Division of Solid Waste in Frankfort. I asked if he had any updates on the hearing and the concrete, outcome of the hearing officer's recommendation, and that has not taken place. Rand, would you like to share a phone call we had as well with Bill Gorton? Anything that you could share from that with the court?
Yeah, as you all may recall, Bill Gorton, who represents some of the citizens that are concerned about the landfill, he had asked us to hold off on filing at least part of the declaratory judgment action because he felt like it was being addressed in an administrative proceeding, which we were unaware of. So we asked him by phone last week to forward us the pleadings just to make sure that, in fact, what was being litigated there is what we would potentially be bringing in front of the circuit court in the declaratory judgment action. And he did send those pleadings, and I'm satisfied that, you know, it's the same subject matter. I've not talked to Fitz, and his opinion, quite honestly, is much more important than mine. I don't think Fitz has the part that we're going forward with ready. I think he's working on that.
And that's my understanding as well. And we did have a conference call with Fitz last week.
Yeah.
And without having that documentation from the results of that hearing, he feels like we need to sit tight still. And, you know, I just wanted you all to be updated on where we were. So it's his recommendation and mine as well that we sit tight, and once we get a concrete result of that hearing, then we can move on that portion. Fitz is working on the second portion that we approved to be filed. So that's the update. Any other questions in regards to that? With that said, we'll move down to 2020 holiday schedule. You know, one comment I just want to share, you know, we passed that out in a calendar format, and then the bottom line is we have to approve the holiday schedule with the dates. But what I would like to do is ask Rand, can we amend the ordinance about that sets our meeting dates to include language that says in regards to the Thursday conflict that we always have at Thanksgiving, could we move that and set that as the Wednesday prior at 9 a.m.? And that way, that's one conflict that we take off. I gave you a copy of the dates, and you also have a date of a copy of the calendar that we shared with these dates inserted with the court dates as well. I just think we're required to go ahead and approve holiday dates.
And also, so every so many years, it's the same with Christmas, if you want to
include that language. Thanks for bringing that up.
So that if Christmas falls on a Thursday, we do it Wednesday.
Which it does next year. Christmas Eve falls on Thursday next year.
Christmas Eve or Christmas Day falls on, because those are our 2 days.
Okay. Yeah, I will prepare that.
All right. So, are there any questions about the presented 2020 holiday schedule? Motion to approve from Mr. Lyons, a second from Mr. Wallace. Any other questions? All those in favor? Any opposed? Motion passes unanimously. And then that gets us to 22. Public comment has to be related to any agenda item. Going once, going twice. No public comment. With that said, I would like to wish everyone a safe and Merry Christmas.
It's not on the...
But I'm going to ask for an motion to adjourn.
Now go ahead, Judge. Tell them Merry Christmas.
Merry Christmas.
We have a second.
Yes. We have a motion and a second.
All those in favor of, all those opposed?
We are adjourned. Thanks, everybody.